Welcome, everyone. I'm Howard Gould, and I'm co-chair of the real estate section for the Beverly Hills Bar, which is sponsoring today's program on escrows. I want to thank the cannabis section for co-sponsoring this program with us. Just as a little bit of housekeeping, you will find in the chat information about getting your CLE credit, which is generally sent out fairly promptly within a day or so after the program is held. Secondly, the chat is not going to be open for questions. If you want to ask questions, please put those in the Q&A for us, and we will make an effort to answer those either as the program goes along or at the end of the program. The next program we have on calendar for the real estate section is an ethics program in January. And please remember, our programs are generally held the third Thursday of the month at 12:30. Ethics is obviously always timely in January, since reporting is required for your MCLE every 3 years by the end of January. So we'll have an ethics program in January. We are anticipating February will be a program on syndications. March will be our annual program talking about the new cases in the real estate area that were important and decided in 2022. Other programs that we're looking at in the not too distant future might be a retrospective and then a current view as to what's happened on residential leases pre or during and post pandemic, and what actually happened in the residential lease world. And we're also contemplating a program regarding the Siri decision and Penal Code 496 and how that may affect real estate litigation and attorney fee and punitive damage collection and those sorts of things. As you know, our program today is based on escrows, some issues that lawyers miss, some unusual escrows, which we are calling holding escrows, and then a discussion of cannabis and how it has some effect in escrow and title and the problems there. We're very happy to have with us today Jennifer Felten and Sally Rowshan. Jennifer is the principal owner of RELAW APC, a real estate law firm that specializes in escrow, title, and brokerage law, real estate development, estate planning, and probate. Ms. Felten has worked in the real estate industry since 1993, and she has been both on the transactional side as an escrow officer and now as an advisor and litigator on the legal side. Her firm represents over 400 escrow firms and advises title companies as well. And she is currently licensed as an attorney, a notary, and a real estate broker. Sally Rowshan has a different perspective for us on escrows because Sally is the owner of Secured Trust Escrow, an independent escrow company specializing in both traditional and non-traditional escrows, such as holding escrows and business sales. After graduating Georgetown University Law Center, she successfully owned her own title insurance company, New Era Title, in Washington, D.C. area, and has been in the settlement services industry since 2002. She's licensed to practice law in both California and Virginia, and active in various escrow industry trade groups in California. And with that, I'm going to ask Jennifer to get us started. Thank you both.
Great. All right. Good afternoon, everyone. So happy to be here and be able to, go over these topics with you. So again, we'll give you a short little summary of what we're going to cover. The overview of issues that lawyers miss. I'm going to cover that section. Then we're going to go to holding escrows, which Sally is going to cover. And then I'll come back and talk to you about the fun world of cannabis and transacting cannabis businesses and properties related to cannabis. So to get started, the things that I think lawyers will find valuable in a discussion of escrow is really, from the beginning, what is escrow? I often have people they don't understand what the purpose and role of escrow is. And that's a really important piece to understanding what they do and what they don't do, because there's a lot of expectations that I see on escrow companies of you were supposed to do this or you were supposed to do that, but that's not the role of escrow. So they really are just this neutral third party in a transaction. They take documents and they take money, And when all of the conditions relative to any particular transaction are satisfied, they then can proceed with closing the transaction. They are a limited agent for the parties, so they are agents and do have fiduciary duties, but they are not, a specific agent for any particular person. They follow instructions, and that is their guiding light of what their role and duty is. If there is not an instruction, it is not within their scope and not something that escrow is going to do on any particular transaction. Now, when it comes to escrow companies, all escrow companies are the same. There are multiple different regulators of escrow in the state of California. So depending on which company you're dealing with, you're going to be dealing with a different set of rules of how the escrow is going to be regulated. The escrow law is in the financial code in California. Financial code 17006 specifically says only escrow companies who are licensed by the state of California can do escrow, except all these exceptions, like any other, it's like hearsay, right? The exceptions eat up the rule when it comes to escrow. So the actual escrow law says only independent escrows can do escrow. Financial code is where the escrow law is. Those escrow companies are regulated by the Department of Financial Protection and Innovation. So the DFPI is the core regulator for escrow. However, banks, trust companies, savings and loans, insurance companies are all exempt from the escrow law, and they can perform escrow transactions. In addition, attorneys, you and I, are exempt from the escrow law, and we can perform escrow transactions in California. Our regulations are in the Business and Professions Code, and we're regulated by the state bar, right? Title agencies. So there's a difference between a title insurance company and a title agency. When you're doing business in California with a title company, it is actually an agency, and they are regulated by the Department of Insurance, and their rules for escrow are in the insurance code. And real estate brokers actually have an exemption to the escrow law. So a broker can do escrow transactions. Their rules are in the Business and Professions Code, a different section than where the attorneys are, and they are regulated by the Department of Real Estate. When it comes to attorneys and brokers, specifically, their exemption is limited. So they are only allowed to do escrows for existing clients. They can't hang up a shingle and say, we're an escrow business. Instead, if they have a client who needs escrow services, they can perform them on those transactions. So again, attorneys and brokers have a very limited exemption to the escrow law. These regulators do not regulate the same way. And your liability and risk and their ability to cover losses and damages can be significantly different. So this is something you should really consider when you're selecting the escrow company for a transaction is, who is the regulator? What level of comfort am I going to have if something goes wrong to resolve an issue? Okay, so that's one of the big things to know about escrow companies. The next thing is, who can instruct escrow companies? I often have attorneys calling saying, do X, do Y. I'm telling you to do this or do that. Attorneys are not parties to our escrow unless it's them personally, right? And unless we have a power of attorney or some other authority, attorneys don't have the authority to instruct the escrow company. Neither do the agents or the brokers, the lender in some circumstances. So it's really important. The parties to the transaction are who can instruct escrow. And on a real estate transaction, that's the buyer and seller. They're the only parties to the escrow. So they're the only people who can tell escrow what to do and can bind them to a transaction, right? So we often have family members calling saying they want to do something, a caretaker, right? Again, attorneys, agents, they are not authorized. So we can talk to them if we have authority to talk to them. But again, we are bound by the instructions of the parties.
Jennifer, my experience on this is that lawyers are all the time communicating to the escrows, sending them instructions to do this or not to do that, and that generally those are given credence by the escrow, even despite what you're telling us about who is actually authorized.
Well, it does, to the point where we will need to codify that request in a written instruction that would be signed by the parties, right? So if you're an attorney, you're representing the buyer, and you say, I want to change this condition, escrow can do that if they write an amendment and then the buyer and seller sign that amendment, right? So it's not that you can't say we want to do X or Y, but the binding of that request comes upon written execution of instruction from the parties.
But where a lawyer writes and says, don't close this escrow for the following 3 reasons, in my experience, that is always honored by the escrow. And if you go to court, the court's going to treat that as an instruction from the party.
I will tell you, if I was asked that, I would send it to the party who the attorney was representing a confirming email at minimum to say, you're confirming, your attorney has said, don't do this, and I'm going to follow that instruction, because technically the attorney does not have that authority. I'm not saying every escrow company does that, but that's what I would want, is a confirmation from the party, especially if, I will tell you, sometimes when we're asked to do something, it's creating a breach. Right. And so if the attorney's asking us to do something that could be a breach for their client, getting their client to confirm that, yes, we want to breach is a really important thing. Right. And so that's the safe way to handle it is get a confirmation from the party, not just follow the attorney. I can tell you, attorneys and agents sometimes go rogue and go beyond what authority their clients actually have given them. And that can put escrow in a very challenging position. Okay. So that's the technical rule and the practical discussion of what really happens, right? Okay. So next, let's talk about general provisions. When escrow receives a contract, for example, a California Association of Realtors RPA, Residential Purchase Agreement, part of that contract actually says that the parties will agree to and sign the general provisions of the escrow company, right? So this is an additional contract that the parties are going to enter into with escrow that is going to govern how escrow is going to process the transaction. The CAR RPA actually makes it a contingency for the parties to sign escrow's general provisions. And it is something that, the escrow companies will send out. It is not uncommon for people to not like the general provisions. Attorneys love to redline escrow company general provisions. And if that happens, then escrow has to review those changes, make a decision if they want to go by the revised general provisions. And I was telling Howard this, if I've got a buyer who's got Howard as their attorney and he comes in and redlines the general provisions, and now I'm escrow and I say, okay, I'm fine with your red lines, I can't just accept them. I still have to take those changes back to the other side. Everybody has to be on the same contract, right? So the general provisions, if they're redlined, now have to be approved by both sides and by escrow, right? We're all entering into a contract before we move forward with the transaction. I will tell you, please read them. They have a lot of stuff in them. They do control how escrow performs their duties and deal with things like a conflict. What happens when we have a dispute? What happens if money's left in escrow? All of those things are discussed and dealt with in those general provisions. They have a lot of impact on any transaction if things don't go the way they're supposed to go, right? So knowing that those are there. Yeah, go ahead, Howard.
Takeaway on this is don't assume you can't change them, because you can change them in a lot of circumstances. And also, it takes quite a while sometimes to look at those. So when you're talking to the client about what it's going to cost and what all you're going to undertake, one of the things you want to remember to tell them is that you will be reviewing the general provisions in the escrow agreement, because sometimes they can be significant. You may well spend an hour or two just doing that.
Yeah.
And then negotiating them.
Correct. There's a lot there. They tend to be pretty significant. Depending, the title companies tend to have shorter general provisions than the independents. I'll just tell you, they have a different legal mindset about this. But it's something that needs to be thought about, because it modifies the contract that came in, right? It truly is a modification of that contract and binds all the parties once we have those.
Jennifer,
yeah,
before you move on to the next slide. We have a lot of situations where the buyer's money is stuck in escrow because the seller is just upset that the buyer walked away, and we have an earnest money deposit. So do you ever see in those escrow instructions, and I say this because I like to put it in mine, that if after a certain time we haven't heard from the seller, we're going to automatically release it and just take that risk of somebody coming back to get angry at us.
General provisions should, a good set of general provisions will discuss what happens if money is left in escrow. And it's a business decision that the company should make when they're creating their general provisions of what to do with funds that get left. Most escrow instructions have an abandonment clause. So after a certain amount of time, you can abandon and send things back. Others will have, clauses that say certain things are going to happen at certain times. Again, depending upon the regulator, there's different rules on what you can and can't do, because independent escrow companies require a higher level of instruction than like a title company or a broker. Most title companies hate holding money, so they will release it, take the risk of the loss, whereas independent escrow companies tend to be less risk, take less risk because they have less resources, right? So they won't take those risks as much. So it's definitely something to think about and know that needs to be dealt with. The general provision should also have a provision to interplead if there is a dispute, if it's over a significant amount of money. Interpleading over $5,000 is going to cost more than $5,000, right? So that's an option for dealing with disputed funds as well. All right. So we are talking about funds, right? So understand an escrow company's funds are put into a trust account, the other people's, right? The money coming in from the parties. It is a commingled non-interest bearing account, right? So all that money gets all put into one pot to be distributed and used as transactions go on. So those accounts will have millions, hundreds of millions of dollars in them at any given time when we look at what size real estate transactions we have today. And so there's systems put in place to minimize the risk of one person's money being taken by someone else because of transactional issues. One of those is the Good Funds Law. So the Good Funds Law is actually in the insurance code and technically only regulates real estate transactions because it is in the insurance code, but it's definitely the standard of care and expectation for all escrow funds, which means we can't close until we have money. Good rule, right? And it determines that how long we have to hold the funds in the account, depending upon how the funds come in, right? So wires are good funds. Other types of money are not. And so if we get a check, for example, we may have to wait a week to season those funds before we can disperse them. Escrow companies do not take Zelle or Venmo or ACHs because all of those are not good funds. And the reason being that you can pull that money back. An ACH can be pulled back for 30 days. Right? So it's not good funds. We cannot use ACHs to do real estate transactions. Again, we're because that's now in a commingled account and we've spent their money and now they pull it out. Now someone else's money has been taken, right? And again, all of these rules are designed for consumer protection. Escrow is a consumer protection function, right? And they also regulate what kind of money escrow can take. They cannot take foreign currency. We can only take US dollars. We also can't take fake currency like crypto, right? So you will see out on the ether, right? If you go online, there are escrow companies that will say they can do an escrow in crypto. They can't. I just tell you, they can. What they do is they convert the crypto to cash to facilitate the real estate transaction. So the buyer may be using crypto, but not the money's not going from the buyer's crypto account to the seller's crypto account, right?
We did a program on crypto not long ago.
Yeah.
And the attorneys seem to be suggesting that in the crypto transactions they've done for buying and selling real estate, that the crypto actually ended up going to the lawyer who converted it and then sent the dollars on to the escrow. I don't know if either of you have seen this happening very much.
It's an exchange.
I've seen it done through the lawyers, but also there are escrow companies who have accounts who can convert the crypto. But it's a vetting issue, right? And the money has to be vetted to make sure that it's clean. So the receiving bank, if it's converted, so if it's the escrow company, the escrow company's bank, or the attorney, if it's the attorney's bank is going to vet those funds and make sure they're comfortable with accepting them, that they're not going to have a violation of any of the rules relative to banking and fund handling, because unfortunately crypto has that ability to avoid those. As soon as it comes into the traditional system, all that vetting starts to happen.
Do you know if the Patriot Act has any interplay here?
It does, from the perspective of the Patriot Act goes along with OFAC, the Office of Foreign Asset Control. So escrow companies and title companies have a fiduciary obligation to the federal government to OFAC check any funds that come in. And it is done at both levels by the escrow company and the title company and the bank. So at 3 different levels, there is a level of vetting of those funds, which are part of the Patriot Act. The second piece, which is in my slides, is FinCEN, right? So which is the Treasury. There's a vetting process. So we'll talk about that part when we get there. Okay.
Jennifer, what about Bitcoin? Is there any difference with Bitcoin?
Yeah. Any sort of crypto, whether it's Bitcoin or Ether or any of the other, they're all in that same bucket, right? As far as they will have to go through an exchange and get converted to dollars to do a real estate transaction legally. And hopefully no escrow company is doing one illegally, right? So fund handling too, the one big thing. So as attorneys, I will tell you, be really careful if you are in any way involved with the transfer of the funds on a real estate transaction. There's a lot of fraud and impersonation. And if you are, as the attorney, are in that process and the money goes where it's not supposed to go, then you're in the lawsuit that happens afterwards when the money disappears. So
yeah, it's so true. Can I just throw in there that
yes,
the biggest group of people that ignore the signature line beneath our emails that say wire fraud is on the rise, and they actually email, sometimes text message me account information, is attorneys.
yeah.
All the time on behalf of their clients or for their own like legal fees. And I'm always surprised when they do that.
Yeah.
But it happens a lot with the attorneys.
Be very careful with transmitting your information, collecting information, pick up the phone and talk to escrow about money. Email is not safe. It's just not. And make sure you're calling the right person, because if you get what'll happen is the bad guy will email you, they'll start communicating with you, and then you'll call the bad guy to verify the wiring instructions if you're not dealing with the right company, because they're really slick. I had 2 wire frauds this week, you guys, on clients. One was $400,000 and the other one was $600,000 this week. Okay.
One question we have so far is, are there any protocols that people are using or best practices to avoid these wire fraud problems?
Yes. So not using email, right, to communicate information regarding financials. Using, so escrow companies will either send the wiring instructions encrypted, or they will send like their information without an account number, where you have to call and get the account number. There actually are some like online services where you can actually do it through an online portal. So there's multiple different options for mitigating the risk. But I will tell you, the biggest thing is picking up the phone, right? And when you pick up the phone, if it sounds like it's somebody from, Ethiopia, it probably is, right? And that's where the bad guys are, right? They're offshore, they're foreign, and they're the ones. And if there's grammar errors, English problems, right? Those are real big red flags. They use British English, not American English, because that's the conversion they get. So if they're spelling things with OUR, right? You're dealing with the bad guy. I mean, there's like literally red flags that you see that you just have to be paying attention to, because I can tell you, and I'm not even an escrow company, but I get fraudulent emails every day on this because people know and see that I'm in that space. The risk is just extreme.
Okay. We notarize in the seller package, for the sale of real estate, we have the seller notarize the information, and then we still either follow up with a DocuSign, because DocuSign is considered secure, and then we also call.
Right.
And so we get yelled at why we're doing so many.
Right. And then people complain because it's a pain in the what, right? And I'm like, okay, so I can waste 5 minutes of your time, or I might send your $400,000 to the wrong place. What would you prefer, right? So that's the discussion we have to nicely have with people over this issue. So we're going really long, so I'm gonna quickly go through these last few slides to get to Sally's section. So just things, if the money is not coming from a party to the transaction, right? So the buyer or seller, we need authorization from that third party to use that money. So no, a third party instruction is commonly an issue with vetting funds. Next, if you want interest, right? Because I said the money's in a commingled account, we can open an interest-bearing account, but it takes time. We need instructions, and often the fees to open it are more than the interest you're going to make on the funds. So now interest rates are going up, maybe you might make some money. If we get asked to release money before closing, there's very strict rules. We need very clear instructions because that's not what is generally the rule. So knowing that's an issue. If we get asked to hold money after close of escrow, that again is a problem because our authority, our duty ends when the escrow closes. So taking instructions after we've closed becomes problematic. So we got to be very clear on what we're holding for. And my recommendation is the money gets released when whatever the conditions are satisfied. Don't think you're going to get buyers and sellers to sign instructions after close of escrow, right? Because once it's closed, they stop paying attention. The only person who will sign is the person who's supposed to get the money. The other person won't sign and will never get that money out of escrow. Again, if we got a fund dispute, right? Howard's come to me and says, don't close for these 3 reasons. And the other attorney for the seller says, no, you have to close. See, these are all the reasons you have to close. Escrow says, you guys figure it out, right? We are not a trier of fact. We can't decide if Howard's breaching or not, right? That is up to you guys to work through. Escrow cannot and is legally not authorized to make those decisions. So I often get attorney letters telling me I have to do X or Y, and they get a letter back saying, no, I don't. And I don't. The law is very clear on this one.
Jennifer, you say that you need authorization from the third party to use the third party funds.
Yes.
Wouldn't you also need the buyer and seller to approve that as well?
So we do get them approved, but so if, you know, generally a third party is mom and dad, right? Bringing in money, or, you know, we've got an entity that is a buyer, but the money's coming from someone's private account, right? So those are the things we're looking at and seeing. If the seller does not have to approve the buyer's source of funds, right? The buyer can bring in their money from wherever they want to. But the buyer has to say, I can use, like, someone can't force the closing by putting money into the deal, right?
Or the buyer's mother tries to put money in that she doesn't want the mother to put in. You really ought to get her permission.
Correct. But she wants the money. But I can tell you this becomes an issue if we cancel, right? So if we cancel, who gets that money? Because everybody wants it, right? At that point, mom, the seller, and the buyer all want the money, right? So that third party deposit actually has language in it, if it's done right, that says what happens with the money, so that we try to mitigate those disputes, okay? And the last one here is cheatment. If we get stuck with money we don't know what to do with, or we can't find, we give it to the state. The state loves escrow companies because we are one of the biggest cheaters of funds. So just know, if you don't pay attention and you don't claim your money, it'll end up with the state. I'm just going to do this quickly. Every real estate transaction is covered by FIRPTA. If our seller is not a legal resident of the United States, we are going to have to withhold a portion of their proceeds. People don't like this. It's 15% of the sales price. So if you do have a foreign seller, we need to be talking about this at the front end because it's a lot of money and they don't like it. And there are exceptions and exemptions that you can apply for, but all that has to be done before close of escrow. And if our seller doesn't have a tax ID number, we've got problems. Okay. So just know this comes up a lot.
I have a caution for people on FIRPTA.
Good.
I had a lawsuit between two 50% owners, both Japanese, of a US company that resolved in an auction with one buying the other out. And the corporate partner from the big New York law firm who drafted the purchase and sale agreement didn't think about the fact that this company had two big pieces of real estate and it didn't qualify to be exempt from being a real estate holding company. And we turned out we had this is like 25 years ago, 20 years ago, we had a $700,000 FERPTA issue that had been missed.
Yeah.
And I'm a FERPTA lawyer, so I happened to think about this and consulted a tax accountant with international background. But you can have a sale of stock and you still need to be careful that there's not a real estate holding company and a FERPTA withholding, because if there's no escrow involved, like we had with the money all changing hands in Japan, the lawyers who closed that could end up on the hook for that money.
Yep. So be very careful. Just know it's out there if we're dealing with foreign sellers. California has their own version. It's the 593. So just know that comes up at the state level as well. And every real estate transaction is going to get a 1099-S unless there is an exception. Sellers don't like it. They think, well, you know, a 1099 is not a go to jail card. It's a notice, and we are a mandatory reporter as escrow. So no, absent an exception, there is going to be a 1099-S on any transaction. I'm going to skip prorations. Just know prorations is one of the most complicated things in escrow. So, and know just how you prorate on whether it's calendar days or 30 days, all those make a difference, especially on a very big deal. Preliminary reports, right? If we're dealing with a real estate transaction, that's the guarantee your buyer is getting. It's insurance. So reviewing that, knowing what the exceptions are, when you review a preliminary report, it's going to list all the things the title company is not insuring, right? That's the exception. So if you want something covered, you got to tell them, because we got to get rid of those exceptions. Just know it can be very big deal on real estate transactions.
One of my major pet peeves about California, where lawyers are not involved in residential transactions for the most part, is that there's nobody involved who really has an obligation to look at the title report. So if somebody asks you, should a lawyer be involved in a residential purchase? The answer is yes, somebody's got to look at those exceptions, make sure you're getting the title you think you're getting, because you know the title officer often identifies issues to the escrow holder that they see in those exceptions, and then hopefully the escrow holder will tell the real estate agents, who will tell the parties, but none of those people have an actual obligation to review those exceptions. And I call it the black hole in residential transactions in California, because you're not buying dirt, you're buying legal title to property that even a lot of the real estate agents don't understand what it is.
Well, and I will tell you, you know, title insurance is the most profitable form of insurance, because people don't make claims because they don't know what was insured and what wasn't insured. So they got a neighbor dispute over an easement. They probably have a title claim and they don't even know it, right? So there's a lot to that whole discussion. Again, I'm going quick because I want to make sure Sally gets her time, but unauthorized practice of law, escrow companies are not attorneys, so do not have them drafting complicated things. They shouldn't do it, but you shouldn't ask them either. You don't want them doing that for a whole plethora of reasons. I'm going to skip vesting. I said FinCEN, residential real estate transactions are covered by FinCEN, which is the Treasury, which flows from the Patriot Act. If we have an entity buyer, we are going to have to vet that entity buyer if they're paying cash. They're looking for fraud on real estate transactions. Okay, I'm going to skip that. The one last one I will talk real briefly. As an attorney for escrow companies, we get subpoenas all the time, right? Escrow companies have a lot of information about people, and we are often subpoenaed for our records. Our records are protected by the notice to consumer rules. So if you subpoena an escrow company, you got to notify the parties. If you don't, we're not going to respond to your subpoena. I would say 50% of the subpoenas I receive don't have a notice to consumer, and we have to tell the attorney, try again. So, all right, Sally, you're up.
Hi, everyone. I'm here to talk about holding escrows. What are holding escrows? My definition of a holding escrow is how I found a way to enjoy being an attorney within running this escrow company. So I get to work with a lot of attorneys, and it's like a pseudo practice of law for me. However, the real definition of an escrow is any type of escrow service that does not involve the transfer of real estate or the transfer of business, a business that specifically falls under the bulk sale law. So anytime an attorney or any parties need a neutral third party to hold funds, usually pursuant to an agreement, that's called a holding escrow. They're a little bit, complex in that the escrow instructions have to be drafted carefully. A lot of times we get legal documents and they're pursuant to a legal document. So I have to make sure that I didn't do anything that modifies what the attorney spent a lot of time doing. So it's simple and yet complex at the same time. It's simple in that all we're doing is holding money, but it's complex because you really have to know what you're doing with respect to holding these funds. In my practice, in order to commence a holding escrow, I require a few things. I require a signed document. Sometimes people call me and say, can I just give you $10,000 because I have a dispute with my neighbor? I usually request for them to give me something in writing to base the escrow off of. If they don't give me that, if the amount of money isn't too high, I have my own form that they fill out. I have to understand the underlying nature of the transaction. For example, yesterday, I had a group of attorneys call me. They wanted me to hold $75 million pursuant to Regulation A of the SEC. It was complex. I have no idea what Regulation A is, so I actually had to consult some of my attorney colleagues because I'm worried about being in the middle of some kind of money laundering scheme. They had a money exchange company taking the money. That money exchange company was going to wire me the money. Bunch of different people were investing that. So, you know, I'm going to talk about the risks of holding escrows, but the escrow agent should understand the legality of what they're doing. Otherwise, you get in the middle of something that you never intended to be. I have to have an understanding of who the parties to the escrow agreement are. These are not like real estate transactions where there's a title company, a real estate broker. We're kind of on our own here. So, and it's by email, it's by phone call. There's rarely any in person. So when XYZ Corporation signs on behalf of the company, I actually have to vet to make sure that the person signing has authority to do so. Who are they within the company? What are they doing? And a lot of times I just hope that it's not some person that got a hold of someone's email. And again, once again, we're in the middle of some kind of, you know, scheme, which is a risk always with these holding escrows. So I always vet who they are. I vet the attorneys. I request copies to make sure the people that sign on behalf of the parties actually have authority to do so. And then I understand what the conditions of this escrow are. A lot of the attorneys ask me, upon the happening of XYZ event, I want you to release the money. I can't do that. We have to have something written right before I release the money. And I get pushback a lot on that. For example, they'll say, as soon as I deliver the stocks, endorsed stocks to you, I want you to release the money. I don't want my clients to sign anything anymore. I have them sign something because I'm always under the assumption that something happened intervening from the time that I received that stock, from the time that they signed the instructions, and I get them to sign a form called an authorization to go ahead and release. Okay, next slide. What are some examples of holding escrows? A holding escrow, like I said, is basically anything that allows us to hold the money. For example, a lot of situations is when an attorney does not want to hold the money in their trust account and they ask me to do it. When a deposit needs to be made pursuant to a settlement agreement. A really interesting one I had a few days ago was there was a lawsuit from the Republic of Armenia with the US resident, and the International Center of Settlement Investment Disputes asked me to hold the money. And when an escrow company won't hold the money post-closing and they're looking for somebody to hold, like, let's say indemnification, something like that, for any reason that they won't hold it, we hold it. Movie productions, I've done a lot of escrows for the entertainment industry where they don't want to deposit the money with certain companies, and you know, we do it pursuant to a movie production. And then mergers and acquisitions, sale of stocks, and EB-5 business visas. Okay, I think we talked about some of the necessary elements. So next slide here. Yeah, so I look for how much money am I holding, what is the purpose of the escrow, who the parties to the escrow agreement are, and what conditions are necessary for the escrow agreement. Procedural matters. Next slide.
Yep.
Okay, thank you. Procedural matters. I already discussed this. I never do single party escrows. Sometimes people ask me to deposit money just so they can show proof of funds to someone. I don't do that. Maybe other companies would. I based on the financial code that we have here, escrow is, there has to be two parties and a neutral third party to hold the money. So we don't do that. Additionally, I have to vet the transaction to make sure we're not in the middle of some kind of money laundering scheme. And back one more, the previous one where yeah. So not every escrow company can do holdings. Why is that? Well, first of all, it's really expensive. We have to have certain insurances. We have to have licensing by the DFPI. Something else that makes it very expensive is that most escrow companies would have to hire an outside counsel to review these documents, because drafting the escrow instructions are rather complex. So, I mean, not complex in the big scheme of practicing law, but in the escrow world, they're a little bit complex. And for example, in my office, no one drafts the instructions. No one takes the calls. When a holding escrow comes in, I'm the only one, simply because of the risk factor. And so, yeah, we have to have separate insurances, bonds. We have to put the money in a separate account. And that means additional fees, that we have to pay accountants, auditors. And then most importantly, you have to have an escrow officer who's very knowledgeable in handling these types of transactions. Okay. And then next slide. Yep. Next slide, I think is, yeah. And once again, I review to make sure that the legality of the underlying transaction. Like Jennifer said, there are some red flags that I've become familiar with. I'll get a call by somebody that said, I'm so happy I found you. I've been looking everywhere. No one does this for me. I'd like you to hold $50 million. And, that's a big number. And the question they ask is, how much do you charge? And I'll throw them some random, I'll get the sense that this might be fake. I'll say $20,000. And then they'll say, wow, that's a great price. Let me send it to you right away. And then I start vetting a little bit and I realize, the number is an international number. Just like Jennifer said, there's an English accent. And they'll give me names of attorneys. I'll get emails from people who are attorneys, and I'll look up on the state bar, they're not licensed. So I can say that I turned down maybe 40%, and either because I'm not comfortable, or a lot of times, I don't know what they're trying to do, how maybe they want to wash some money through this escrow. I have no idea, but there's a lot of fraud in them. So, it's a little scary, but I've developed some kind of risk management for myself. And what else? I think I'm done.
Yeah.
Higher risk, yeah. Yes, the remote, I don't meet anybody, unfortunately. Once in a while, I do get them to notarize, so I make sure I'm actually talking to a real person. And there's, yeah, like everything, there's a risk of unauthorized practice of law, which,
you get at least the benefit of being a lawyer.
Yeah.
So, I mean, that really, when you're dealing with that kind of stuff, using a lawyer, and Sally is, and there are some escrow officers who are lawyers, that's definitely something to consider when you're dealing with some of this more obscure and complex work, right? All right. Thank you, Sally.
Thank you. Thank
so
you.
Got a few minutes left. We'll talk about our lovely cannabis escrows and kind of how we deal with those transactions. So, I'm old enough to remember Just Say No, right? Nancy Reagan and, our the war on drugs. Cannabis was actually scheduled as a Schedule 1 drug controlled substance back in 1970. Right. And so that's when we started having the control, and it just ramped up from there. Right. And so what happened then is in 2013, there is a shift in mindset about cannabis and how it should be regulated and banked, and that's really the biggest issue when we're talking about escrow, because we gotta put this money in a bank. We get the Cole memo in 2013, and the Cole memo says you can do it, just don't, they kind of lower the bar and standards of regulation of cannabis. Without legally doing it, just by a memo from the Attorney General, right? So that's the world we've been living in since 2013. So you have states decriminalizing, they're not legalizing cannabis, right? They're decriminalizing it. They're two different things. But so across the country, we have decriminalization of cannabis. And so then, how do we deal with that from a transactional standpoint? Because we've got factories and we've got farms and we've got retail facilities all doing cannabis. They need to still do everything else that every business does, right? The businesses get sold, the properties related to them get sold, and someone has to do those transactions, right?
Jennifer, isn't part of the problem that it was decriminalized at the state level, but technically not decriminalized at the federal level?
It is still illegal federally, right? So cannabis is still a Schedule I drug. There have been multiple attempts to deal with it at the federal level, but it has not happened yet, right? So cannabis money is still problematic if we want to put it in a bank. So what happened was people were doing real estate and business sale transactions through title and escrow, depending upon the circumstances, but just not telling title and escrow that it was related to cannabis, right? There were some red flags sometimes, like this Buds for You is the name of the company we're selling, and Cannabis R Us, maybe there's a cannabis connection, maybe we noticed that. There are a lot of things that do come up, but often these deals were done through title and escrow without the title or escrow company knowing that there was cannabis. You got all kinds of problems from that. If the bank realizes it, because there is a vetting process with the funds, those funds can be seized by the bank. And I have had funds seized on transactions. I've seen that happen. In addition, if you're selling a real estate property that has a cannabis connection and you don't tell the title company, you're wasting your money buying title insurance, because as soon as there's a claim, the title company is going to deny it because of that cannabis relationship on the property. You're wasting your money buying title insurance without telling the title company there is cannabis on the property. But if you tell them, then we have a different discussion to have. But just know those are some of the things we deal with. So banking cannabis is really the issue, right? Most banks don't take cannabis money. When they do accept it, they are required, if they knowingly take cannabis related monies, they have to do what's called a suspicious activities report, so an SAR report. And so the reality is that a lot of cannabis is still done in cash, right? They can't take credit cards. So at the retail level, it's cash. And from a practical standpoint, cash is king in the cannabis space. So banking and trying to do a real estate transaction can be very challenging. Yeah, go ahead, Sally.
Sorry to interrupt you. I just wanted to point out that there's two title companies that I know of that are insuring, OC Title and Stewart, although they're very difficult, but they're insuring cannabis real estate. And then there's two banks that I know of that are holding cannabis money, Bank of California and East West Bank.
Yeah. So there are workarounds, right? And that's where we're at today, though we weren't there even 5 years ago, right? And so this FinCEN, the same people who are looking for bad guys buying properties are putting out a report every year about how many banks are taking cannabis money, right? So this is the FinCEN report from the end of 2021. 553 banks reported taking cannabis funds in 2021 and 202 credit unions. So there are places that you can bank, but it's still hard. Sometimes they won't tell you, right? Trying to get the list of who will do it can be challenging. In addition, a lot of banks that are out publicly saying they don't do it do. Again, they just don't talk about it very much because it's a lot of money, right? And banks make money off of the money that's in the bank. So it is doable. You can bank cannabis related money, but it's going to get vetted, right? It's not going to just, they're not just going to take a truckload of cash, right? So cannabis money is actually ranked differently as it comes to the banking system. So tier 3 cannabis related funds are businesses that are doing business with cannabis companies. So non-plant touching is kind of the terminology. Accountants, lawyers, property owners, right? So if I got a cannabis tenant and they're paying me money, I'm the landlord, I am a tier 3, but my tenant is a tier 1, right? So I can get a bank account and my bank will let me take money from a cannabis party, but they wouldn't, a lot of banks will take bank tier 3, but not tier 1. They won't bank my tenant, but they'll let me take my tenant's money, right? So just know cannabis money is ranked and it changes how the bank's comfort level and the vetting relative to the funds. And again, so when we're escrowing it, the escrow company has to have a bank that's willing to do it. There's only a couple in the escrow space that will do it. It needs to be a legal cannabis operation, right? So licensing has to be part of it. Getting a title company, and there are a couple who will. If it's a business sale, because of the way cannabis is regulated, they are done in 2 phases. So if we're selling a cannabis company, unless you want to stop operating, you're going to sell part of it and then wait and then sell another part of it. So knowing how to do it right to not get your business shut down is a big deal. And then one of my biggest things, so I will say I did cannabis transactions for a while as an attorney because none of my escrow clients could do them. And I was having to say, well, you gotta, as soon as they find out it's cannabis, I'm like, you have to resign, you can't do it. And you need to tell them to take it somewhere else and don't tell them it's cannabis. That was the answer because no one was doing it. And that was an awful answer. So I was able to set up a bank account and vet them. The biggest issue was, so my buyers on my cannabis deals want to bring me cash. So they're like, I have $1 million in cash. And I say, no, well, you can have as much money as you want in cash. I need the money to be deposited in the bank in a wire or a check. So I'm not taking cash, right? And so getting the money into the escrow is often a challenge. And then I would have sellers who'd be like, well, I don't have a bank account. So my buyers don't have a bank account and my sellers don't have a bank account. I got to have a place to send the money once I get it, right? And often the answer was, oh, my Uncle Vinny will take the money. And I'm like, no, 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 I cannot send your money to Uncle Vinny. You're going to have to figure out where the money's going to go. So I will tell you, often I sent the money to the attorney's trust account and the attorney could figure out how to get the money to the party. But those are real issues that we don't see on a normal transaction.
Jennifer, my issues were that they call me and they're high. Like they just laugh uncontrollably. All of them, buyer, seller, sometimes the attorneys.
There is some very interesting people in this space. I will say it is a very interesting space. And so if you are going to be doing business in this space, even as an attorney, right? If you're taking cannabis money for your attorney's fees, your bank could shut you down. There are attorneys who've had their trust accounts and their general accounts shut down because they were doing cannabis business. Okay. So fund receipt, you got to pay attention to it. How are we doing it? And, are we okay? If we got a loan or a lease on a property, it probably says you can't do anything illegal on the property, right? So we better be talking about that. If we got to insure this thing, right? We got to talk to an insurer and get it insured in a way that they're going to be comfortable with cannabis. Title insurance, I talked about. There are 2 underwriters, right? There's multiple agencies, but 2 underwriters that will underwrite cannabis. And it's not the big ones because the big ones, Fidelity, First American, they all have banks. They won't touch it, right? So it's the non-traditional title companies. Treasury, right? If we got cannabis money coming into a bank, it could get seized. There are suspicious activity reports done on these transactions, right? And what if we have a problem? What if someone goes bankrupt? Well, you can't go bankrupt in the cannabis space. So that can cause all kinds of challenges if we're in the middle of a transaction and there's some bankruptcy issue. And technically, it's a RICO violation to touch cannabis money because it's still a Schedule I drug. So you are a drug dealer even as an attorney or an escrow company or a title company, if you're doing a cannabis transaction, and you could have a RICO issued. There have been title companies sued for RICO, private RICO actions relative to cannabis. So no, that's that's a risk in this space. It's not common, but it is out there. So
Jennifer, it sounds like if you're going to take all the risks of doing this, one of the things you need to do is have a separate trust account separate from everything else in your law office. And that
yes,
trust account is only for cannabis transactions.
absolutely.
And probably at a bank different than the one you use normally.
You should definitely have redundancies. I was at an event at one of the bar associations, and this attorney is in the cannabis space, and he had not told his bank, and they found out, and they seized his account the day of payroll, and he couldn't pay his employees, right? His employees did not get paid, and he had to deal with that disaster area. It took him a week to get his money out of there and be able to resurface and function. So yes, just knowing you are in a risky space, and put the protections and charge the appropriate amounts for the level of risk you're taking if you're in this space. Okay. All right. That was the end of the slides.
Okay, in terms of what you just talked about, what you charge, and that's the one other question we have for Sally from our participants is, how do you determine what fees you're charging and how are they calculated? And I assume you're going to tell us one thing for your real estate deals and something else for these one-off sort of holding escrows.
For the holding escrows, I determine it case by case by talking usually with the attorneys. It's as low as $850 for a very small amount, and I think the most I ever charged was $20,000 on a very, very complex one. But I base it on how much money I'm holding, complexity of the matter, whether there's a dispute, how much time it's going to take me to write those instructions. And let me tell you, when there's attorneys, they butcher up those escrow instructions so many times. And so I would say that the average, I would say majority are somewhere around $2,000, but it's case by case.
In 2000, how much money would you hold in something where you're charging a $2,000 fee? What's the maximum?
On 2000, what's the max? Like, let's say an $800,000 settlement, that there's a settlement agreement and they want me to just hold the money. Sometimes it's even less than that. If it's easy and the attorneys are easy to work with, I've been really fortunate that I've had the luxury of working with really nice people. I ask them, does this meet your expectations? Is your client okay? A lot of times they say slow, sometimes they say, could you knock it up by a few $100s? I've almost never gotten pushback on fees because I can't charge it as an attorney. I have to charge it as an escrow agent.
Well, what if you're holding $20 or $30 million in something like this?
I think on a $20 or $30 million, something easy where it's clear to me what they're doing, not with this regulation A where none of it makes sense to me. On 20 or 30 million, I probably would do somewhere like 6, 7, 8 maximum.
Very good. I want to thank both Jennifer and Sally for joining us. Very interesting presentation. Obviously, there are some twists and turns people need to keep in mind. And unfortunately, we do see peculiar things happening sometimes in real estate escrows and all kinds of other escrows. But that's why we have Sally and Jennifer to call upon when we need to. And I want to thank all of the people who attended and hope we'll see you at our January ethics seminar. Thank you very much. And thank you to the Beverly Hills Bar.
Thank you, Howard. Jennifer.
Thank you.